local town board or any other department, and it's for education. But some of the topics that we'll speak on short-term rentals, and a topic that a number of civic associations like past that we come to speak about. It's kind of the protein of this specific show here, but we also will speak about dark skies, fences, corner properties, how they need to comply with fence laws, the noise code. We were asked to talk about dogs and animal control as well as signs. I will say that the sign code is part of 280, which means it's subject to the zoning update. So if you've seen the new zoning update, actually it kind of still a long chapter on signs, but it has photographs that's a little bit easier to comprehend. So we're not going to get into signs that much, but I'm happy to answer any questions that you have. But we're going to start with short-term rentals. So essentially what happened in the last decade is the proliferation of short-term rentals based on Airbnb has become big business. Essentially, you can make about 4 times the amount in a year if you rent your house short-term than if you rent it. And what the issue is that with that is we have a housing crisis, and you'll see that data that we've discovered is showing that a lot of these houses that are used for short-term rentals otherwise sit. So here is some data from 2020 showing the total number of units in the town. So 40% of them are vacant. So not advocating either way, just giving you facts. I've done this before. People that come here, you know, they kind of advocate short-term rentals, and people that come here and advocate that we should, you know, put them in jail. Just giving you facts. So you can see between 2023 and 2024 how there's more and more of these popping up. We actually recently just went into contract with a company called Deckard. They're going to be able to tell us a number of things about how it comes to rentals, including when someone will be checking into rent, how much they paid. Essentially, it's going to be able to scrape through websites, and it's going to be able to tell me exactly when someone's checking into their Airbnb, how long they're staying, what they paid per night, what each person, each individual household is making per year. This is what they're telling me that they can tell me. We just recently got a contract with them. They're actually mapping the whole town right now. They also have a contract, I believe, with the county, and that's specifically to collect the hotel motel tax on Airbnbs. So they are going to be coming for their money. The county wants, you know, they're not going to be skimped on their hotel motel tax. It's different for us. We don't have the ability to tax technically because the county has that ability. Actually, they don't share it with us. It's kind of unfortunate, but we use that software for different purposes, really, to see where is the issue. This is provided from a website called Airbnb, which is now paid for it. But it's a similar service, and it's going to allow us to really have more data on what's out there and what's happening. But it's a business, so essentially you can make $100,000+ a year on average renting out your house. So you know, out here that's a big full-time salary. So if you're able to do that, you know, a couple of times and that's average, right? So we actually have a number of people that are making a lot more, and we're able to tell that. So this is broken down by hamlet. You'll actually see that Orient surprisingly has maybe less overall rentals, but the average daily value, the average daily rate is very high, and the occupancy rate is also very, very low. So you're seeing your average annual revenue is almost $120,000 to have an Airbnb in Orient. So it's not as prolific out here, but it is prevalent. And you can see kind of breaking down across the whole town. It's interesting. I mean, it's certainly something that our eyes have been open to it. So why do we care about this, right? I get this question a lot. Why do you care? Let people make their money. It's their property. Okay, fine. It has an impact on affordable housing. It has an impact on community character. You don't know, there are instances where people are coming in and telling you, well, it's a new house. Someone's in this house, in and out every week. It started off, I think, in the Hamptons as it was party culture, right? You had people coming out, they're making noise. It's not the same issue now. I don't get as much of that. Because most of the time, we sort of the community folks aren't going to be able to afford to spend, $400 or $500 a night, not for a week. It's not what Montauk was 5 years ago. The problem is more, you don't know who your neighbors are. There are people coming in and out of houses. It's changing, and you're losing that community element, I guess, is what people, the complaint that people are having. We also have 4 LLCs managing 40 properties. So that's big business. And if you break that down, $100,000 per property, that's a good amount of money. So we actually, you'll see later in a few slides, the town actually put a task force together. I was lucky enough to be on that task force to kind of look at this and say, what do we want to do about this? What can we do about it? And these generally are just starting off very broadly. What can we do? Well, we have a moratorium on short-term rentals. Well, it's too late. They're already here. They're already happening. You can't have a moratorium on something that is not technically legal and is happening rampantly. So the horse is out of the barn now. We're too late for that. So we can use our zoning authority. So what that means is the town has 2 ways to regulate. Right? You have their police power. So that's health, safety, welfare. You can regulate short-term rentals with your police power. However, it's much easier to be scrutinized by a court. You want to use your overall zoning authority to treat each property equally. Right, you want to regulate the use, not the user. It means that essentially these laws are going to hold up in court when you're using zoning authority, treating everyone equally rather than your police power, and singling out different people and regulating the user. You don't want to regulate the user, you want to regulate the use, and you want to use your zoning power to do that. Also, permitting and fees. Just a note there. So you can't. If you were to have, say, a short-term rental permit, you can't make it a per se tax. So you can't say, okay, you're allowed to rent your house on a short-term basis. $20,000 is how much we're going to charge. You can't do that. The permit has to be based on the administrative costs, right? So how much does it cost to go through the application process for that permit? Otherwise, it would be illegal. It would be considered a per se tax, and you can't do that. So you can rationalize the cost of a permit only based on what it takes administratively to process the permit. And that's, paying for things like this software, having someone, administratively go through and file that permit, all those things. But you can't just tax people and charge them because you don't like it. And there's actually, this is, you'll notice Shelter Islands on here. There are a number of cases throughout the country that are coming up, and essentially it involves constantly. Every few months, there's a new case in somewhere, kind of shaping where short-term rentals are allowed, what the courts are willing to accept in terms of how they're regulated. These are a few of them. Really interestingly, Shelter Island, that case stands for the fact that can have a period of time such as 14 days, that was upheld. New Orleans is a very interesting case because they actually said, not getting too much into the weeds of the law here, but they actually said in New Orleans that regulating short-term rentals based on residency was a violation of the dormant commerce clause, which essentially means that you're treating someone that an out-of-state actor different in an in-state actor, which is violation of the dormant commerce clause. Only Congress is authorized to essentially say that to do that. Really, is without getting into the weeds there. It's actually one of the more conservative circuits, and we've just found that a New York court is a little bit more comfortable with the dormant commerce clause argument, regulating kind of out-of-state and state actors. But essentially, most of these cases are saying that you want to regulate the use and not the user, and essentially, yeah, not going to get into the weeds.
So that has to do with who owns the property.
Correct. So if a New Jersey owner is renting compared to a New York owner or someone who lives in Suffolk County or lives in Southold versus someone who lives in New Jersey, you're regulating interstate commerce because you're saying that the New Jersey actor can't do business essentially across state lines. But again, New York courts are finding that there's other ways around it. That case is becoming I will start from New Orleans, and Fifth Circuit is becoming more of an outlier. It was concerning to me at first. New York courts are a little bit more comfortable saying, well, we don't necessarily see that quite the same way that the Fifth Circuit does, and unless it goes beyond the Fifth Circuit and one of the higher courts takes a look at it, it doesn't seem like it's going to be a huge issue in New York, but it's constantly evolving. Sure.
If you're using the zoning as your mechanism, what's the enforcement?
So you could, for example, I don't think we're proposing this, but you could say, okay, you're allowed to do this commercial activity in, say, a commercial zone. I think we probably wouldn't do that. And again, this is just my opinion. We probably wouldn't do that because if you were to say, okay, you can have this more commercial activity in commercial zones, we have such a limited amount of commercial space here that what would happen is uses that are more intense would kind of have nowhere to go because a commercial zone would be filled with Airbnbs that would essentially be houses.
I guess I was asking, let's say it's a 14-day or 30-day limit, and if somebody's in violation of that, how do you enforce that to make that?
So essentially, we will get into that. So what you do is you have an officer come to, this is how it's working currently, and it's very hard to enforce. You essentially have a complaint-based code enforcement. So we receive a complaint, constant turnover. We would send an officer there. They would investigate. Essentially, they're knocking on doors and they're asking people questions, and they're getting people to sign affidavits saying, my name is Joe. I live in Brooklyn. I've been here for 6 days, and I paid $3,000. And that's it. Then the owner gets it.
And if you have that data from your
correct. So that's how we've been doing it. Now we're going to be able to have this data. We're going to know that Joe's there. So we're going to be able to have someone. Hopefully, this is what they've told us, right? They don't have the software yet. They're currently mapping the town out, but from what we're told, we're going to be able to know that someone has booked. As soon as they book, we can have someone meeting them at the town. Again, it's complaint-based code enforcement, so you have to follow a complaint to kind of trigger someone going out there. But yes, this technology hopefully will help enforcement come into this century.
Does complaint-based enforcement lean towards that being discriminatory potentially?
So actually, it doesn't. It's the opposite of that, right? So if it weren't complaint based, it's more likely that it would be discriminatory, right? Because we're only acting when there is a complaint. So if we were just going around picking who we were enforcing this against, it's much more likely to be called discriminatory, right? So it's complaint based, in my view. It's either complaint based, you're knocking on all the doors. If you're in the middle, who's to say that, an officer, someone is not picking on, say, the person that makes the most money, the person that lives in this town? I think the complaint-based aspect of it avoids that. But certainly open to decide, yes.
So there would be a penalty of sorts, a fee. It's not a penalty, we'll call it just an expense of renting in this area, but then what do you do with the money? Do you put it toward low-income housing? Is there a circle?
Yes, that's a good question. So there's two things we bifurcate that. One is there's a penalty for doing it, because right now it's illegal, right? So you're coming in and you're paying a fine. That fine goes through the justice court, essentially goes into the general fund. You could make the penalty, there's ways to make the penalty go to certain areas. I think that's possible. It's not something that is impossible to do. You can write code that says this penalty goes to this fund or that fund. I don't know if we've gotten that far. I think right now it would just go into the general fund and be spent however it's spent. But that's not impossible to do without that. Yeah, it has been brought up, not only in this context, but in others. Yeah, right. Yeah, absolutely.
So Ben, in terms of the data that you previously presented, where you showed there was an increase in short-term rentals from month to month.
Sorry.
Does that data come from permit data, or where do you get
So
it?
that data comes from the source. It's a website called Airbnb. Essentially, what they're doing is they're using technology to scrape Airbnb. It was a free service. Now it's quite expensive because they realize every municipality is kind of catching up to this. So that's where that data is coming from. It's partially from our planning department. Also, I know Margaret Stein, you were put together a lot of this data as well through FOIL requests to the town attorney's office before I was there, which is nice. That sounds like a lot of work for whoever got this FOIL. Yes.
Are there any incentives to stop people from doing short-term rentals? For example, if you rent your house full-time, will you get some tax or something?
So we can't, unfortunately, we don't have the ability to do tax breaks.
Or something else?
Right, now I understand, I think we're certainly discussing that. That would have to happen at the county level. But yes, we're thinking about how we can make it to incentivize really long-term rentals. And right now, what the practice is essentially, you're just, if you get caught, you're coming in and paying a fine, you increase the fines significantly. Or how they're enforced. The fines were always the same, but we have made changes to the code, including you have to have your permit number in the advertisement, and the penalties for that are quite strict. I think they go up to $8,000. Yes.
Perhaps you catch more bees with honey. Maybe if you were to advertise that this is a contribution that people who rent out, short-term and long-term, that there is a percentage of their income that they could put toward low-income housing. Then maybe you'll have people volunteering to get you money. You don't have to go hunting them.
That would be great for me. You don't like having to find people $1,000 personally. That is something that the task force has discussed. We're also putting a code together, a new code, an updated code, because right now our code is quite old. It actually comes from years ago, and they did it a little bit piecemeal. So they were only willing to go so far with it. But this is essentially what our code says now. You do not rent your house out for less than 14 nights consecutive. So that's 2 weeks. You have to have a 2-week rental. So knowing this, you have to also have a rental permit. We don't right now look at, there's only one type of rental. You can rent year round. That means you can rent 15 nights, or you can rent year after year after year after year. There's no in between. What we know about the permits is there's about 1,000 active permits. Almost as many are sitting in file because they couldn't get the permit because, they have an as-built something. So they don't have all their COs, they don't pass their inspection, so their permits are sitting in a file because they need to come back for something, whether it's a variance, whether it's a permit for an as-built deck, whatever it is. That's the situation. So we don't have seasonal permits. We don't have a way to tell how long people are renting. It's an antiquated system, and it's also something that we're hoping to update with the new code, and also hopefully implementing some technology. And know that East Hampton recently just made it so every time you file a building permit, the only way to do it, it's online. You don't go to the office. You submit all your paperwork online. It's publicly accessible, and it's a tough task, moving from paper to into the modern era. But I think it's something that eventually has to happen.
But you're saying that at $100,000 a unit, 980 units, we're saying it's $100 million business here in this town, 23,000 people.
And half of the houses here, essentially.
And kids who grow up here can't.
I'm very lucky to be able to. The only reason really that I am able to is because my grandparents had 8 kids. I'm the youngest of the grandchildren. I got very lucky during the pandemic. Otherwise, I would not be here. I'd be in Manhattan. So, that's what it is. Most of the people that most of the people that I grew up with, either they're business owners, and that's why they're out here, or they have moved on. That's part of the issue. So it's something we have to look at. I mean, there's also, the housing crisis nationwide. We kind of have to look at it in that perspective as well. But that's where we are with rentals, and we're actively working on the situation. Yes.
Do you think if these hotels continue to go on multiplying units, that it might help ease the disparity in hotel pricing and Airbnbs, and trying to step back and see it from a grander perspective to drive that, because it's 4 months, it's June, July, August, they're making $100,000, it's hard to resist.
Yeah.
So, what would change that would be year-round industry or more availability of hotel rooms.
I'd love to see, I don't know how they will study it, but I see your point, and I thought about that. One thing I will say is it's less of a seasonal thing than you would think. There are more people that are coming out here in November, December, January. There's definitely a dead season, but there are people out. We're coming into that season, and it gets very, very busy for the code enforcement officers in my office coming up. But we're finding that it's more of a year-round thing than you would think. As to whether allowing these hotels to come in, I don't know. Personally, I'd love to see a study on it. I don't know if there's any data out there. It kind of makes sense when you think about it, right? Maybe allowing hotels to come in, it takes away from that. There's also just, I think, a type of person that when they travel would prefer to stay in an Airbnb than a hotel. I would rather, if I can, go away. I'll stay in your Airbnb if I can. Go away with friends, all those things. If there's no hotels available, it's just Airbnb is a thing. We're not going to, get rid of it. I think you just have to regulate it a little bit. But that's a good question. I think there's something there.
So you referenced the task force from your work on future regulations.
Sure.
What's the timetable for the task force to come forward with a with their recommendation to that board?
So it should be, I would say in the next year. I don't really want to speak for the task force, but I would say in the next year. Again, that's something that I'd rather you go through the town board and get an answer for that. I don't want to speak for the task force, but we're certainly working on it. And as you know, there's a million things in the air, but getting the technology is something we need to know what the technology can do to see how we can essentially write the law. So once we have the technology, we'll be able to better understand. Nobody likes hearing that. Write the law, get it done. Let's do it now. I totally understand that. But I think there's something to be said for taking it step by step and doing it right. And that's what we're trying to do.
Is the intention to update chapter 280 as a consequence of this?
I don't know if it has to be in 280. So 280.
As the mechanism.
So just because we're using your zoning power doesn't necessarily mean it has to be in the zoning section. So 280 is obviously undergoing a massive update now. There's been discussions of throwing this in there as well. Personally, I think that might just take more time. I think you can do this as a separate chapter.
Or you can do it as a subsequent amendment.
Right, exactly. I don't know. Personally, I wouldn't want to see this get stuck in kind of waiting for 280 to be updated. I think it's simpler. It's not easy, but it's not a 200-page code. It's probably 10, 8, depending on what the board eventually decides they want to do with this. It's not as complicated as updating the entire zoning chapter. It's what can we do? What are we allowed to do? What's feasible for us? What do the legislative body want to do with this issue? When we know that, we'll have a code and we'll be able to enforce it.
Let me just say, we could probably spend an hour just talking about this, so.
Wait, I just have one
we
last
should
question.
move.
So, because I helped do this. And I know that Ben has done a whole presentation of an hour and a half just on short-term rentals. So how many of the short-term rentals are owned by individuals or families and or by LLCs?
So again, we have that slide that says I think 4 LLCs on 40 properties. Some of them are not owned by LLCs. Some of them are more mom and pop. Some of them are, my grandmother died and I live across the street and we keep the house in the family this way. I get that too. It doesn't mean that it's legal. Is kind of my take. I unfortunately have my position is that I have to treat everyone the same, even if it's the person where they're trying to keep the house in the family. I get it, but you're still breaking the law. I'm certainly empathetic towards them. It's something that hopefully the new code can be able to look at. You can't simply say though that because something's in an LLC, you treat it differently than it's being owned by an individual. You can't kind of discriminate based on having a limited liability company own something. But there is something to be said for, okay, we're able to keep this house in the family. We're able to substitute our income by doing this. So we're kind of going to come back to short-term rentals a little bit in a minute, but these are the general code complaints from 2023 to 2024. The big ones are short-term rentals, building permits, lights, and noise. We'll kind of get into that as we get out of the short-term rental month here. So this is a list of who was on the short-term rental task force. Essentially, a lot of people come together meeting many times over the summer. So essentially the point where we made a recommendation to the board, there's code being drafted, we're getting technology. It's of course nothing government works especially fast, but we are certainly diligently working towards coming to a solution of some sort. So here's essentially what was presented to the board, specifically this particular slide. This is what kind of outlined as our options. Do nothing, leave it as it is, right? 14 days. Prohibit all short-term rentals less than 30 days. So kind of take an approach that other towns have. So just extend it to 30, and so you have to rent out for an entire month. So you can restrict short-term rentals to owner-occupied primary residence. That was something that, that Heidel Stark case that I talked about, it could have kind of, if that case was still the governing law, that would be enough. Bang my fist there, reminding, hey, remember this case, guys. But it looks like New York State courts, New York federal courts are going to be a little bit more lenient there. So we might be able to kind of incorporate that somehow. It's still worth it. You could allow a limited number of short-term rentals per capita in each hamlet and have some kind of lottery system. So essentially, this idea would be, okay, every year, every 2 years, you're allowed to rent short-term as many times as you want if you get a permit that costs X. You limit the amount of permits that are available to 1% of the residences in each hamlet. The permit costs a lot of money, and that's it. Everyone else is illegal. It's something we could do. It's an interesting idea. There are positives and negatives to it. It's kind of taking a more realistic approach of what we have, not totally expanding short-term rentals because there is an extent of, like we said, the other option is hotel. You also don't want to build business out here. So that's essentially what the options that were displayed to the town.
I think New York City's mechanism is that anything less than 30 days is defined as a hotel.
Right.
And only zones that are allowed to have hotels as a use are options for short-term rentals. I mean, there's an enforcement issue there as well.
I mean, yeah, it's hard to compare town to the city. But
Honestly, you could control where.
Right. True, and that's kind of the idea of, okay, limit it to 1% of residences in each hamlet. So essentially, we're saying you get this permit, you can do short-term rentals, but you're reducing the number. It's not a perfect solution. It's an idea. The problem with saying you can only do it in certain areas is because you're making so much money doing this, you're going to push. So say you do it in the light industrial area, right? You're going to push. That's an intense use. The intense uses belong in that area. Is a short-term rental intense use? Sure, but what's going to happen is you're going to put essentially a short-term rental is going to take the spot of, say, I don't know, I want to say a sand mine. Sand mine is illegal, but that's what industrial sand mine or some kind of other industrial use that is needed, but can't make as much money as a short-term rental. So the worry is that you would push these other uses out of the area that they're supposed to be in and bring a more residential use to that area. I don't know if there's credence to that. I think that's kind of the worry. So, okay, would we be pushing this very lucrative business into an area that maybe it doesn't belong, pushing something else out?
And then the lottery is basically a random distribution that changes.
Correct. So the idea would be to, okay, the lottery, you got your permit in 2 years, you can rent in 2 years. The problem I have with that is, what if year I live next to you and you now rent in 2 years? That person is going to be a little upset, I imagine. You could also limit it to each side of your lot, right? So maybe it's only allowed in R40 district. So your neighbor gets the permit, at least they're farther away from you. A lot of things, have to be discussed. We're certainly open to hearing what you think about that. But that's kind of what we're talking about at this point. So again, possible permitting structure here. You can have a cap on permits. you can have, if you're a primary resident, maybe you're allowed to do it more than a non-primary resident. Again, that I got to start dormant commerce clause treating people different, kind of rings in my head when we were saying that, but it's something that's being discussed. You're going to want to say that the permit is a privilege and not a right. That really means that we can take it away from you if you misbehave. And we're learning how this happens from a number of municipalities that are doing this, specifically places like Lake Placid, a lot of places on Long Island now, a lot of places across the country are implementing these kind of restrictions. So we're kind of using the best practices and looking at how different municipalities are trying to figure this out. But here's what the technology hopefully is going to start doing. It's going to give us the ability to monitor who's where and who's paying what, and get us more data to kind of see what the issues are and how we can best enforce it. I know I've talked about this a little bit, so I'm going to move through this a little bit more. But yeah, it's a combination of speaking to the community, finding what the needs are, and having staff training, and also implementing that technology. So this is another Katie Hoggan from the Association of Towns. Writes a lot about short-term rentals. She gives a lot of talks. She gives almost every couple of months, it seems now, a legal update on what the case law looks like across the country. I'm telling you, it changes constantly. We thought Iowa Stark was going to be something that said we couldn't do certain things, and all of a sudden, new cases out in New York are saying maybe we can do that. So it's actually an interesting thing to watch as well. But I think that's all I have for short-term rentals. So if you have any more questions on short-term rentals,
Let's save them to the end.
This is interesting. So this is the lighting code, 172. Interestingly, something we do get a lot of complaints about. People don't generally understand that when you have a light outside, it should be facing down. Kind of dumb this down for you because there's a lot of technical terms. And so when I try to explain it to people, this is how I explain it. The light should be facing down and it should be enclosed, right? So nothing, if you have a light, it should be going down. No light should be emanating up towards the sky. The exception to that, which is interesting, is you are permitted to uplight the American flag. So, we get a lot of, there's a light on. Uplight the American flag, and the code actually says that the town encourages people to take the flag down as opposed to uplighting it, but it's permitted. So uplighting trees without the flag, flagpoles, all those things, you can't do it. It is prohibited. Obviously, there is difficulty enforcing that. Until recently, we didn't have a part-time code enforcement officer. In the summertime, you start at 8 o'clock, and you have code enforcement officers that have union contracts and work 8 to 4. It's hard to enforce dark sky compliant. That being said, you can see if a fixture is enclosed. I can walk around, and now I kind of do. So that light's not enclosed. I have a change that. But that's.
But the
Yes.
anything that existed before the code, so you have to be able to prove that it's a new fixture.
So yes, so I have a little bit of an issue with that, right? Because that's you're kind of saying you're using the pre-existing non-conforming. Which if you go down that rabbit hole, I mean, okay, fine. It's an interesting one, but if I say I have a pre-existing non-conforming use, it's my burden to prove. And I have to establish that it was never abandoned. So if I was actually fighting this legally, burden shifts to the person that's trying to establish the use. And I get to sit back and say, okay, what do you got? Because you have to prove to me that, and this is kind of silly talking about lights, I know, but just as a general fact, that person has to establish that whatever that use was was in effect and never abandoned. So if it's taken out of use for 2 years, we've abandoned use and it's exterminated. And also, it comes down to, like many things, speaking. A lot of people have found difficulty talking to their neighbors. And I think if maybe you just had a conversation and said, well, the lights are shining in my bedroom window and it's, I'm having a hard time sleeping, you probably get a better reaction than if you call code enforcement and we send a car out there and say, hey, you got a light complaint. There's only one neighbor. I don't know where it could have come from. But that's part of it, yeah.
Well, I think there's so many people who just don't even know about this law,
That's true.
which is a terrible issue. And I'm an architect. I designed an addition to the house diagonally across the street from me. And my client went out and he got a clear glass light with a filament bulb that just blinds the eye. And then the house across the street has a post with the same sort of filament bulb, which is, harkens back to colonial times or a flicker, but there's no enforcement.
Yeah, there's no enforcement and people don't know. So it's like anything, right? It's education and enforcement. We do, a lot of times the enforcement is part of the education. So a lot of people have no idea. Their lights are on a timer, they don't live here, you hear everything.
But for people who are coming in and filing new building permits, could there be, as part of the application, a disclosure about the lighting so that they would know to begin with that they can't put this illegal lighting in?
So yeah, I think it's part of the planning process. So if you have a site plan, that would be something they looked at. I don't know if part of the building permit.
Yeah, that would be
process.
for commercial.
Right. So I mean, certainly something that that has been suggested. A little packet, perhaps, or even a poster where you apply for your permit and get, X, Y, Z. I think that's probably part of the whole bringing the permit application process into the century. Possibly putting them online. People are maybe have them saying this, but I think that you could implement that somehow. I agree.
Is the town exempt? Is the biggest light pollution around here?
Some really, some. So first of all, that's a common question. That's not the time. So that's
I guess that's
PSEG.
the street lights are.
Yeah, so we own the right of way. PSEG owns the poles. I have heard this. They certainly could have better lighting. I'm not sure. Technically, no. It's whether you want to get into a battle in justice court with PSEG. I think you're more likely to try to get any poles they replace to be compliant, as opposed to saying, "Hey, PSEG, you now have to replace every single light pole in town." I mean, I personally, I think it partially through the planning process. I know there are some communities out there that have underground electric. And there's no telephone poles, so there's no lights, and it can really make the neighborhood nice. But this is just kind of a best practice from the Dark Sky Coalition. You want to turn the lights down, you want to keep targeted, you want to use warm colored lighting, and only use it when it's needed. A lot of people, I don't know if it's they're moving here from somewhere else, but are using light as kind of a security device of some sort. So they leave their lights on all night, all the time. They're not at the house. So we kind of have to talk to them and say, hey, you gotta turn the lights off.
How do you address holiday decorations?
So holiday decorations are exempt in the code. Yeah, so we'll actually get into that, but this is kind of the basics. Business lights, the light has to be mounted on top and only illuminate the sign. So security lights, essentially you want to prevent that glare that comes off the corner of the light. And it's, it's somewhat basic stuff. It's just, it's difficult to enforce. And it's a lot about education. So yes, holiday lights are exempt for a certain period of time. during, from Thanksgiving to January, they have to be turned off at 1 a.m., but they are exempt from the light code. Neon is also not permitted, but again, LA-lights are exempt from the provision. Light trespass actually is in 280. So there's the lighting code, and then there's something called light trespass, which is in the zoning code, which is it's under uses permitted in no districts, and it's actually right by transient rental properties. There's light trespass, which is
both well hidden in the code.
Yes, yes. Well, I think it's probably because they didn't know how to enact.
Especially the 14-day thing is very well hidden in the code.
Maybe well, okay. I think the story behind that is they were only going to go so far in regulating that specific thing at the time, so they kind of just squeezed it in there. People get very confused when I try to explain that. Well, this is what you violated. Now you will look at, so that's part of what we're trying to do is put all of that in one place. So at least if you go to the zoning code, you can see, okay, if I'm having this short-term rental, here's what I can do. That's part of the kind of helping people figure out what the law is. I actually found there was a state law that died on the vine a few years ago. Anthony Flambeau was actually one of the people that brought it forward, but it kind of shows why we're doing why dark sky codes exist. It's not just because light is annoying. It has serious effects on not only human health but migrating birds. Most birds migrate. They aren't able to migrate past certain cities because of the light. They use the night sky to migrate. So around Manhattan, of course, you can imagine a lot of birds get, bewildered, concerned, they're disoriented, and they don't make it back to where they're migrating. So this is kind of the preamble to the state level light code that died on the vine, which I found quite interesting, and it kind of really puts it in perspective. It's not just about light annoys me, I don't like lights. It has serious health consequences and serious quality of life consequences, not only for humans but for animals as well. I thought that was interesting. Leave you with that. Any other questions on light?
When I drive back at night, every business has its sign lit up and it's closed for hours.
Yeah.
So why aren't they?
So some businesses are going to be allowed to do that. Depends on where they go. Also, we're complaint-based code enforcement. So if no one's complaining about it, they're generally, unless someone's driving by, this happens in the summertime with signs, specifically banners. I find specifically when they're put on the corner. We'll kind of get into this with hedges and fences. When a banner, first of all, you shouldn't have a banner sign unless you're a farm. We'll get into that quickly as well. But when the sign is in the way of, say, traffic or a sight line of traffic, that's when a code enforcement officer, if they see it, will go and speak to someone right away and say, hey, this sign's got to go, or you're going to get a ticket. Because it's a public safety issue. But whenever we get a complaint about lighting, that's when we do it. And of course, it's becoming easier because we have a part-time guy now, but he's been very new first couple of weeks. But we will have an ability to have someone on the ground at night. But let's talk about fences. We had some talk about fences. So fences can be up to 4 feet high in the front yard, 6.5 on your side of the rear yard. And then deer fences, you actually need a building permit for a deer fence, and they can't be in your front yard. Deer fences also have to be, I think they have to have about 20 feet between poles of a deer fence. And also corner properties. This is kind of an interesting one. So if you have a corner property, either a fence or a hedge, that hedge call it the 30-30-30 rule, right? You have to have 30 feet clearance on both sides of the road. And if you have a fence or hedge, it can only be 30 inches. So it's about 2.5 feet. This is something that is unfortunate because a lot of people have very nice hedges. You either have to tell them hedges down, or you have to move them, which can be unfortunate. Some people have beautiful plans, but if you're making, say, a right-hand turn on a corner property and you can't see around the corner, somebody could get killed. So that's what that law is about.
Mhm.
Yes.
So your fences would be 6.5 feet, 8 feet.
Deer fences can be up to 8 because a deer can jump over.
Maybe it's up to 6.5, you don't get a permit.
Correct.
So when you're above 6.5 to 8 feet.
Correct.
That needs a permit.
And specifically, deer fences have, because of the way they need to be built to actually prevent deer from jumping over them, they have other specific design implements that require a permit. And now, of course, same thing with signs. A lot of bona fide agriculture, New York State ag markets is going to come and say, no, your town code is not superior to New York State ag markets law, and they will allow, say, a banner sign to exist at a farm. So we can't mess with ag markets.
Do we
Yeah.
define agricultural, that is regulated down between commercial agriculture, winemakers, farmers, and residential?
Residential, so when you say residential, I'm smiling because this is a kind of a philosophical discussion I've had a number of times about what is and what isn't agriculture. So are you saying like a residential in terms of a residential farm, or are we talking about? Yeah.
Ungrown tomatoes.
Backyard.
Right, okay, no, so bona fide agriculture is gonna have a specific definition. It means you make so much money, and this comes right from ag markets. I think we took their definition, we put it right into our code, because we can't get more, we can't really regulate past what ag markets allows. So we just took what they had and that's what we use. But it's gonna say, I make this much money on this much land every single year to be a bona fide ag producer. So that would be the difference. Hope that answers.
Everyone should check out the new code because there's new definitions.
There are.
That's another topic.
That's for next year.
Yeah, that's.
Well, actually.
No, that's for our
that's
annual
for our
meeting.
Annual meeting, we're gonna be talking about the zoning update. Yeah, we gotta
This
listen to that.
is noise. So I will say noise is a very hard thing to enforce. I'm just going to be plain honest with you. And here's why. Essentially, what you need for noise, the way our code is written, is you need to have someone on site with a noise meter. Doesn't sound hard, right? But the noise meter is not only wildly expensive, it needs to be calibrated every year, which is also wildly expensive. They're not easy to use. No, because I've tried using the one that we have. It's not easy. It requires a lot of training, and the maintenance of the system. It's more difficult than anyone really would think. But we have had tickets for noise when it gets completely out of hand. And most of the time it's dealt with, but hey, you gotta stop making so much noise, you gotta stop doing X, Y, and Z. You try to reason with someone because it's difficult to prove. It's difficult to prove without a noise meter and someone at the property on site that there's a noise violation. See when it's based on decibels. Now there are the disturbs a reasonable person of normal sensitivities. It kind of is a way around that, but having someone on site, on scene with a noise meter that meets certain standards and needs to be calibrated every year is difficult. I think, almost akin to having a machine that reads your blood alcohol content if you're pulled over for drinking and driving, right? That machine has to be inspected, it has to be regulated. It's the same concept. But it is something that I know Supervisor Krupski has gone to a number of meetings to discuss this issue since he's taken the helm here, and it's something that we are working on. This is what the noise code says. Certain times, certain decibels. Again, it's hard to tell you what exactly 65 decibels is, but this is what the code says.
There are decent phone apps.
I know. So that's the one thing that they do. They work well. The problem is the way the code is written. You need a ANSA certified noise meter, and that means that it has to be to the American National Standards Institute's version of whatever their standards are. We have to meet them, and whether an iPhone video meets it, I doubt. So that's part of the issue. Whether an iPhone app would hold up in court, I don't I kind of doubt it. Because we have had people send in video with an iPhone, and we're all kind of like, right, this person's correct. This probably is a violation of the law, but the way the code is written, you have to have someone on scene with the noise.
But that would be a reasonable, if you're talking about the reasonable.
Sure. Yeah, absolutely. No, I agree. That is a kind of a way around it. It's probably the code needs to be altered, and I know that people are working. We do. It kind of sounds like I'm saying we can't enforce this. It's not the way I'm intending it. I'm just pointing out the difficulties that you might not understand. Because we do get people calling and saying, "Oh, another noise complaint." I have to explain to them, well, I need my sound level meter, I need my person on site, I need someone to say, this is non-volume.
Are people looking at banning gas powered mowers?
Yes, so that's what we're getting to here. Whether they're looking, I mean, it's something that's brought up. We can. So right now, gas-powered leaf blower cannot be used by a commercial landscaper performing a commercial landscaping service during these times. Again, tough to. Somebody calls state code enforcement and says, well, first of all, not going to be anyone until recently, would be anyone there on Sunday, Saturday, or Friday evening. So you can see how that would be difficult historically for us to enforce. It's one of those things where you have to be there and see it. So now we will have more ability to respond to these kinds of things going forward. But in the past, it's been, okay, this is happening on Sunday, we get a call on Monday. It's not a crime in progress. There's nothing an officer to go see, look at, and write a ticket. So it's kind of been, hey, we know you're doing this, but we're working on that as well. There's also a number of exceptions to this. It's actually a surprise how many there were. So any kind of agricultural equipment, one agri markets is going to come in and say, no, you can't regulate that. Also, we have historically being farm country, we have a farmland bill of rights that's going to say if you're actually in an agricultural area, you have to allow for certain sound to exist there. Some of, going back to the gas powered leaf blowers, the town is exempt from that. So are golf courses, cemeteries, and properties in commercial and industrial. So those are things that are exceptions to that specific code. I know East Hampton has banned, I believe, gas powered leaf blower. I have a number of friends actually that are very adamant about the fact that they should be banned. It's something that's discussed.
We'll work on it.
I don't know if we're actively changing. All right, so kind of moving a little bit quicker here. asked to talk about dogs. So generally, dogs should be restrained on a leash. I do spend a good amount of time in a lot of our trails and parks. I do see a lot of dogs unleashed. I happen to be a dog person, but I'm also the person that when a dog bites someone in the town, I am the one who prosecutes the dog and the owner. It's changed my perspective on having your dog off the leash. You can have a great dog, and the dog can have a moment, and it can bite someone. It gets very, very ugly. So I personally would advise you to leave your dog on the leash. It is, it's very unfortunate when a dog bites someone, and it could be a great dog, and it just has a moment. And unfortunately, if that person complains, has serious injury, the dog can be put down. It's not fun. Yes.
Just curious if there's a code about dog barking, the noise of barking dogs.
There is. Eventually, you can actually have. It's ag markets is going to govern mostly dogs, and again, it's one of the areas where we can't go beyond what ag markets says. So our code is going to mirror exactly what you would see in New York State ag markets law. So yeah, dogs barking is considered a nuisance. If it goes on too much, you can call the town, and there can be a hearing brought against that dog. You can ask you to move the cage. You can ask for a number of things. I think ag market says that the dog can be muzzled. These are not the fun parts of my job, but it's kind of a cautionary tale. My mom has 2 dogs that we kind of share, and I never take the dogs off the leash. I don't care if I'm on the beach, if I'm on the trail, and these are like pretty lame dogs. It's an older lab on the fly, but just from my experience, you want to keep the dog on the leash. It's just that simple. Whether it's to protect it from other dogs or to protect it from itself. And that's yeah, so it's a little strange in saying here that you have to have the ability to immediately leash the dog. But it's saying previously that the dog has to leash.
Well, no, you can have, they can be off leash, but not from May 1st to October. You're allowed to have them off leash on beaches
So
between October 1st and May 1st.
So this is saying beaches, if the dog or domestic animal is restrained on a leash from May 1 through October 1, between the hours of 9 a.m. and 6 p.m. So these are talking about specific town beaches. So
Right.
what you're talking about is park district that allows dogs to run. What this is saying, I know where you're coming from with that, but what this code says is that it can be on a beach if the dog or domestic animal is restrained on a leash from May 1 through October 1 between the hours of 9 a.m. and 6 p.m. I know that specifically Bailey's Beach in Matatuck is famous for, as park district property, is famous for kind of allowing dogs to be off the leash. That's not town property. I know what you're saying, and I've heard the same thing. This specific section of the town code is saying that they must be restrained on. I know that there are different sections, or maybe not sections, but there's different places that you may be able to do this. This is specific to these specific towns.
Mm-hmm.
We're talking about beaches that have town. All right, so signs.
I think we can go quickly through signs.
Yes. Again, going back to the whole ag markets thing, you can have a sign, can't regulate farm signs, can't otherwise have a banner sign. We get a number of complaints on signs. Most of the time it's just they take them down and that's it. You can't have one of those things that they have car lots that waving. You can't have those. They can essentially go into the road and basically blind drivers. But that's really the extent of the sign. So if it's lit, it has to be lit from the top and down lit. The lighting can only go on the sign. And there are a number of exemptions from the sign code. I think temporary real estate signs are exempt. A number of things, political signs are exempt. We are actually working on political signs to pull together. So money, signs at the end of the year. It's working on it. But I think now I'm going to hand it over to Anne, unless there's any other questions.
No, I think probably Anne will just do an overview of the role, and then we'll probably do a separate forum just on the Historic Preservation Commission. But please.
Thank you, Ben.
I'm Surchin, I'm the vice chair, Southold Historic Preservation Commission. And I'm here today to talk about historic preservation and what the commission does. And it's kind of funny because we meet and people come in and you see them along one side of the room. And you always look at their faces when they come in there. And half the time, the expressions are such that you would think these people are facing a root canal. And that's the first thing of the case. But I think that what we do is somewhat misunderstood. We have in Southold Township 2 National Register historic districts that come under our purview: Southold Village and Orient. East Marion has its own district, but there has been no resolution submitted to the town to adopt that as a historic district in those national register. So they don't fall under our purview. There are individually led buildings throughout the township that are very significant, that are not part of the district, but those properties, because they are properties, are required to come before us if they're going to be renovations, additions, alterations, or even sometimes just repairs and replacement of certain parts of the structure. And so people come to us, and most of the time it's for renovation and alteration, a replacement of some deteriorating part. And sometimes they come to us with conditions that, shall we say, are not subservient to the main part of the house. So that we have certain standards that we go by, and our standards relate to the Secretary of the Interior standards for rehabilitation of historic structures. And so I'm going to go through some of this to tell you what we do and we do not do. Thank you. The most part, the things that we look at are, we have there are general guidelines that dovetail with the National Register and the Secretary of Standards, which, by the way, you can find on NPS.gov. That's the National Park Service.gov. And it's really about a huge document, but there are certain chapters in there that relate specifically to renovation, alterations, additions, etc., whether it's commercial or whether it's residential. So basically, the guidelines consist of identify, retain, and preserve. And what this means is that the identification, retaining, preserving the form and details of the architectural materials and features are an important part of defining character of any building. And this is always listed first in the recommended area, the parallel not recommended area, listed types of actions that are most apt to cause diminution or even loss of the building's historic character. And it should be remembered that, such loss of character is just as often caused by the cumulative effect of a series of actions that would seem to be minor interventions. So the guidance, in all of the not recommended areas must be viewed in a larger context for the total impact on a historic building. And some of these minor things that happen is that there's just a tremendous potential over a period of time. So, many distinguishing features are damaged or run away. And that's not too much of a problem out here, but we do see that on occasion. You want to protect and maintain the materials that are original to the building, that are intrinsic. This can be done through the process of rehabilitation work, protecting and we address these issues when people come to us. For example, protection inclusive maintenance of a historic material through treatments such as rust removal, caulking, limited paint removal, and reapplication of protective coating, and the cycle cleaning of the roof gutter systems. Now, this is not in our code, but this goes to everybody's common sense that if your gutters are full and they're wood gutters, they'll start to rot, they will overflow, they'll start, going up the roof and, causing a tremendous amount of damage to the building. So just, maintenance is such a huge issue with just maintaining historic structures, and a lot of it's not that hard to do. But sometimes people come to us and they want to replace their gutters simply because, they haven't been maintained. Then we also go to the installation of fencing, and that's a very big deal in a place like Orient Village because so much of the existing fencing is historic, and people want to put up fences, and they have to conform to the town's height regulations. So do you replace existing, or if it's a more contemporary structure, do you allow that, a more contemporary fence to go with that structure? Within the historic district, there are non-contributing structures that are not specifically landmarked. And so when people come before us with those structures, we want them to blend in, we want them to be good neighbors to their neighbors, but we don't necessarily use the kind of hard-ass criteria that we use with all of the historically designated and recognized houses. We're a little more lenient. If they want to replace their casement windows, which are appropriate for that period with an in-kind replacement, we let them do that because it's not changing the character of the neighborhood. So that was a lot allowed to with those houses. And yet, if they want to do a big addition, we don't want them putting on a second story that dwarfs every other house on the street. It changes the streetscape. So those are the kinds of things that we take into consideration, for that particular type of addition. And then there's repair work. Some people just come to us and they say, well, our masonry, our wood, architectural metals are deteriorating, and we give them advice and we tell them, no, you can't go out and replace that material with some other material. It goes to replacing in kind when you do repair work, and some of the things and some of the features are dentures, historic brackets, steps, plaster, roofing that has to be replaced. And using the same type of material is always the preferred option. And so I think that, it's great because when people come to us, we're like, in a way, a clearinghouse. We can tell them where they can find this particular material. Or in Orient, for example, there are quite a few buildings that have metal shingles on the roofs here. And I'm sure you've seen them, sort of silver or I think sort of faded gray. And they're interlocking, it's sort of like a Y shape. And they're as easy as pie to put on. And there is a manufacturer that still makes those very roof shingles. So, you know, people can come in, we can tell them who to call, where to go, and they're not even that expensive. You know, and they can be placed in time. So we're sort of in a way of clearing house. We offer guidance to people who are looking to just maintain and repair historic features on their homes, and which is really important in a community like this. Now, looking to place them, you know, I usually we try to repair it first, but when it has deteriorated beyond redemption, then you try and go out and get the same material and replace in kind, or let's say you'll have a historic fence, rebuild it in kind. You know, sometimes people come and they want to change it for various reasons, and you know, we listen. And so sometimes we approve a change, you know, that there's a little bit in certain ways. Sometimes we don't. It really depends on each individual situation that we do. It should also be noted that, you know, we go by the National Park Service guidelines, and especially with character defining features on a house. And there are certain well-defined circumstances where they never recommend removal and replacement with new material or the feature that, although damaged or deteriorated, could reasonably be repaired and preserved. And so some of the issues here you have to do with the fact that sometimes repairing it is more expensive than just replacing it. You know, and so we see these conflicts on the patient. Other times the repair is really minor, even though the person coming in thinks it's going to be a big deal. But in terms of the Secretary of the Interior standards, they want to first try and repair it if at all possible before you consider replacing it. Now, when it comes to alterations and additions to buildings, basically, if we're continuing use, the alterations and additions, not sympathetic to the existing building, but to the neighborhood as well. And we don't want to, really destroy any of the original character-defining spaces or materials or features and finishes. What we don't govern is what's going on inside the house. We have no authority over, what people can do in the interior of their homes with regard to their plaster walls, their woodwork. I mean, you could have a beautiful historic house on the outside, and somebody decides on the inside to rip everything out and make it completely modern. We have no jurisdiction over that whatsoever. And that's in some municipalities, they have that jurisdiction, especially in New York City with certain interiors that are just, priceless. They just redid magnificently the Frick Museum and the interior. Silk wallpaper that they replaced, which was completely rewoven with the original patterns, the raised patterns in the wallpaper, mounted on the walls in this room on the second floor. And I mean, what an undertaking that was. Yeah. But we don't want that. So anyway. sometimes the construction of an addition is absolutely essential for building, for new use. But it should be avoided if it's determined that those needs cannot be made by altering secondary or non-character defining interior spaces. And we don't really get into that, but the alternatives really have to dovetail with the nature of the neighborhood. And one of the things that's been very problematic, which we did a lot of research on in the last year and a half, was solar collectors. You know, we basically came to the conclusion that we don't want to see them, and this goes with the standards of the Park Service for rehabilitation. We don't want to see them on the roof on the front of the house. And sometimes it's a gable roof, so people come and say, well, it's a gable, so it faces this way and that way, but you still see it from Main Street. And that we had one case that for us was a little heartbreaking because the people wanted it so badly, but I mean, it was such a visible intersection off of Village Lane that no matter what you did, you could see it, and such constraints of the property, they could only put it on in a little pitch here on a flat roof, and anyway, we had to turn them down. And but that was after we did a lot of research and through the National Register publications, and we felt that we came up with the compromise that if you wanted an alternative spot, even if you built a little knee wall on top of the house that was not offensive, you know, where they could be shielded from public view. That, you know, in certain circumstances that could work. And that seems to be one of the biggest problems. Can you see it from the street? Can you see it from the street if it's set back 150 feet on the roof of the historic garage? I mean, this is the sort of thing that, you know, we talk about all the time. We say, well, there are trees there, and it kind of, you know, camouflages it, but this is the other thing that goes on, where landscaping is considered ephemeral, because, you know, shrubs and trees can die, they can come down in hurricanes, so it's really not a permanent camouflage of what's going on with the house behind. And people ask us all the time, but that's really not something that we accept, or in other National Register historic districts that they accept. I mean, we wish it could be, but it's beyond our control. You know, I mean, if the shrub would never die, well, that would be fine, but it just doesn't work that way. Yes.
Question about fences. I've heard varying stories about fences. Sometimes they're in your purview and sometimes they're not in your purview.
Well, it depends. Sometimes people will come to us and they have a non-conforming, non-contributing house, you know, and they want to put up a fence. So that's very different than putting up a fence in front of an 1880s landmark house in the village, which may have had a fence there to begin with. If you go through our archival records and you see pictures of, you know, one of those real cute little Orient fences. So it really depends on the individual situation. Amy Folk, the town historian, a couple of years ago, came up with a whole series of acceptable looking fences for the Orient community. And she did a tremendous amount of research, and we have access to that as well. So if people come before us, they can, you know, they can ask us what kinds of fences would be acceptable. And this was all drawn from the historic fabric of fencing in the National Register District. And you know, we're happy to present that information. Most people don't know that. Yes.
I wonder what the commission's role is
the disaster we had going on for I don't know how many years on neighbors. Well, we were not in favor of, approving what he did. I mean, what I'm talking about is he came to us to put this extensive renovation addition on the original house. And, they had to put, well, let's start with the barn, okay, before we even get to the house. He came in about 10 years ago or so, maybe Robert Harper will correct me if I state anything wrong about the barn, because he was on the commission and we were wrong, what he did. The barn was originally in the middle of the property. And he came to us and wanted to move it to one side of the property so it could be access to the street. And that wasn't a bad idea because then it opened up the whole interior of his property. From a landscape planning point of view, it gave him more property to use. It would have been very lovely if he had just done that. But we allowed him to move the barn to its current location, which was going to be, I 14, maybe 16 inches out of the ground at best. And then he started renovating the barn. He started changing it that in a way that deviated from what we approved. And then it became one stop work order on him after another. And then a few years later, all of a sudden, from out of nowhere, without a building permit, without going to the CBA, he added on to the foundation wall and lifted it up 4 feet above grade. And they put a stop work order on him. And at the same time, he had developed this whole master plan for his property, which, included the swimming pool in the front yard, and put all this foundation work and retaining walls all over the place. And they did a stop work order again, and he went before the zoning board, and they completely shot him down. Right now, nothing has been happening. What I think, this is only my personal opinion. I mean, it's not, but there is something in the world of preservation called demolition by neglect, where a property owner just doesn't do anything to the building. They just let it fall apart and they go, whoops, it all fell apart. Now I can build a new structure here. And I don't know whether he's run out of money or whether he's just doing demolition by neglect, but the original house is, starting to fall apart. It's on ribbon. We need one great hurricane to just push it off, and that'll be the end of it. So I just don't know what he's doing. He moved to And the town doesn't seem to be doing anything.
They don't seem to be doing it.
I don't know, is it in the?
No, it's okay.
Is it?
There are 3 active lawsuits.
Well, I was just gonna say.
Yeah, so that's all I.
The big lawsuit is gonna be when somebody gets killed. That is an incredibly dangerous place. Fortunately, you don't see kids running around. That surprises me. I've lived here 50 years.
If I were the town, then I would ask for him to put some sort of fence, in particular around the house on the perimeter, be that orange plastic 4 feet high, and just surround it so nobody goes in there and gets hurt. I mean, because that is like something terrible waiting to happen.
Well, the town could do that.
It was ankle, break a leg.
Then that would be really lovely too.
I want to go down to expression. If you have a non-conforming, non-contributing asset, and they want to replace vinyl siding on their house, what are you going to do on that?
We don't really approve of vinyl siding, okay? What's underneath vinyl siding, or was the vinyl siding original to the non-conforming house?
It's a 1960s.
Well, I mean, you could replace it with other materials that look like real wood, but aren't vinyl. You can
So it kind of, so it's always a guideline, right?
Right,
So,
I mean, we don't approve of vinyl siding.
Right.
Yeah.
yes, I know.
So, but if it's in the historic district and it comes before us, we can certainly suggest other, rather affordable materials, like if the vinyl siding is like mimic cedar velvet siding, they can use hardy plank and paint that. And once it's painted, it doesn't look any different than painted cedar siding. And, it's made out of concrete, it breathes, I mean, so.
I'm on your, HBC report, so I
Oh,
totally
okay.
understand. But when push comes to shove,
But it's not just a guideline. If they can require that.
you can withhold the COA, but it is a guideline, and I believe if the individual wanted it badly enough and went to court, it can't be defended.
Well, it's very interesting that you say that because nobody has, in my years on the board, which is 10 years now, I can't remember one person coming to us saying they wanted to replace their vinyl siding with vinyl siding. I don't know what else to tell you.
It's
Robert,
I agree with everything you said about the industry. And I would like to address that too. But there is a flaw in the law, and since we have one of our town attorneys here, maybe we can address it. And I've been trying to get this straightened out for years. There is in chapter 170-5, section 5B, is the definition of the buildings that are under the purview of the HBC. And in there's a word that is eliminated with a goal of difference. The word is contributed. And what essentially is saying, you have jurisdiction over the contributing houses in a historic district. That means you don't have jurisdiction over the non-contributing houses. And that means that that person who Dennis just talked about wouldn't be under the purview of the HBC and could therefore do whatever they want. And I think all of you who are here, that live here, if there's somebody with a non-contributing house, and there are many right along the street here, they are not subject to your approval. Okay? So if you have a historic house next to one of those so-called non-contributing houses, they can do what they want. And essentially, what I would consider rule the neighborhood, because in the historic district, everything contributes.
yes.
Every single building, what you do matters to the houses around. So I am asking our attorney friend here, if you would look at chapter 178, 65B, and look at the word contributed, and see if that could be removed from the law. It would make a huge difference in the power that this commission has in doing the right thing.
Except I think the code says. Yeah.
Very interesting. There are people who have non-contributing houses, and they file for building permit, and then it gets kicked to us, and they still come before us, to seek, advice as to what they should do, which is really interesting because they don't have to do that, but they come anyway,
Well, I disagree with both of you because I think what the code says is that if it's listed on the national or state register or is a contributing structure, which makes no sense because it's everything. Well, as far as the state is concerned, everything in the district is listed. Now, yes, I've spoken to the people there, but as far as I'm concerned, if it was built after the district was designated in 1976, then it shouldn't be included because of the way our code is written. But okay, I think we have to end it there.
I think we're going to have to end it very soon. I'm sorry, but I think we should come back to this with a separate discussion just about historic districts. What is a district? Because that's another conversation about the boundaries of the district. And there's a lot more to talk about here. It's just that we're already getting up to noon.
Yes.
And if you would be willing to allow us to have a separate session just on HPC and historic districts?
Well, yes, but there are some things that I would just like to go over with, it's like a pointed checklist of things that are really important when people come before us, and it's just 10 items. I can read them off really quickly.
Yeah.
Okay. And this is, basically in terms of applying the standards. A property shall be used for its historic purpose or placed in a new use that requires minimal change to the defining characteristics of the building and its site and environment. Another one, the historic character of a property shall be retained and preserved. The removal of historic materials or alteration of features and spaces that characterize a property shall be avoided. Each property shall be recognized as a physical record of its time, place, and use. Changes that create a false sense of historical development, such as adding conjectural features or architectural elements from other buildings, should not be undertaken. That's one that really gets under my skin. Most properties change over time. Those changes that have acquired historic significance in their own right shall be retained and preserved, so that if you have a 1930s Art Deco edition added on to an 1895 shingle-story house, you have two historic components that are layers of history, whether you like the way they're juxtaposed to one another or not. Distinctive features and finishes, construction techniques, and examples of craftsmanship that characterize a historic property shall be preserved. Deteriorated historic features shall be repaired rather than replaced. Where the severity of deterioration requires replacement of a distinctive feature, the new feature shall match the old in design, color, texture, and other visual qualities and where possible, materials. Replacement of missing features shall be substantiated by documentary, physical, or pictorial evidence. Chemical or physical treatments such as sandblasting that cause damage to historic materials shall not be used. The surface cleaning of structures, if appropriate, shall be undertaken using the gentlest means possible. Significant archaeological resources affected by a project shall be protected and preserved. If such resources must be disturbed, mitigation measures shall be undertaken. Like when I was doing a renovation in Sag Harbor, we were adding a new foundation, and they dug up the dirt for the foundation, and we found a skull there, and we found a bone there. My father was a doctor. He said the bone was a tibia. And they stopped it, until it could be resolved, whether this was a murder, whether it was, Indian bones, so those things can happen. New additions, exterior alterations, or related construction shall not destroy historic materials that characterize a property. The new work shall be differentiated from the old and shall be compatible with massing, size, scale, and architectural features to protect the historic integrity of the property and its environment. And this next one's really important, and it's the last one. New additions and adjacent, related, or new construction shall be undertaken in such a manner that if removed in the future, the essential form and integrity of the historic property and its environment would be unimpaired. And that's it.
Thank you.